Constitutional Court decision on Lungu 2021 not conclusive. As reported previously, the Constitutional Court delivered its ruling in a case that sought to establish whether President Lungu was eligible to stand for re-election in 2021. The court determined that Mr. Lungu's tenure between 2015 and 2016 did not constitute a full term of office because he had held office for less than 3 years. Everyone has interpreted that ruling as the court effectively handing Mr. Lungu a third-term bid. As promised, we will look at the judgment in detail and review some of the main issues considered by the court. But first, a little background. On 28 October 2014, it was reported that Zambian President Michael Sata was dead. This was the second time a Zambian president had died while holding office. The first was Levi Mwanawasa, who died on 19 August 2008. Now, Michael Sata's death nearly threw the country into a constitutional crisis because while Sata had appointed Guy Scott as his vice president, he often picked a cabinet minister to act as president each time he was away. So Guy Scott was vice president, but Edgar Lungu was the acting president at the time of Sata's death. Article 38 of the Constitution then said, "Whenever the office of the president becomes vacant, the vice president shall perform the functions of the office of president until another person is elected as president." It did also provide for a cabinet minister to hold the transitional office, but only in a case where the vice president was unable due to physical or mental infirmity. This unique situation led to a power struggle between two camps of the ruling Patriotic Front Party. In line with the constitution though, Guy Scott took over and became acting president during the period up to the 2015 election, and the PF chose Edgar Lungu as their presidential candidate for the by-election. Guy Scott did not qualify to stand for election as president, as the constitution then only allowed candidates for whom both parents were Zambian by birth or descent. The 2015 election became the fourth presidential elections in Zambia in less than 9 years, meaning that more state resources were being channeled to yet another costly election. That intensified calls for adoption of a running mate clause. This then became part of the constitution with the passing of the Amendment Act of 2016. It means that going forward, when a vacancy arises in the office of president, the vice president automatically takes over to finish that term. So, when we consider the two ways the constitution is interpreted, 1. Literal meaning of words, and 2. The purposive application. The running mate clause is clear. Reading it literally creates no ambiguity or absurdity. And then taking the purposive approach only serves to understand the intention behind the provision. We know that the running mate provision was included so as to make for a smoother and less costly transition in the event that a president vacates office due to death or any other reason. So that would be the purposive interpretation of that provision. Next, the framers of the law considered what would happen to a person who automatically takes over office as president in case of a vacancy as stated above. They must have considered that such a person may have presidential ambitions of their own. And since the Constitution clearly states that a person who has twice held office as president is not eligible for election as president, the legislature included a provision to only enforce such a limitation if the candidate held office for at least 3 over 5-year term. The specific clause is under Article 106, and paraphrased it reads, "A person who automatically assumes office of president as stated above will not be deemed to have held office if at the time they took over office less than 3 years remained before the next election." The literal meaning of this is clear, and it applies to a person who was a running mate at the previous election. The Constitutional Court has decided that this ought to apply to Mr. Lungu as well. And the lawyers arguing the case for allowing Mr. Lungu to stand in 2021 put forward that if the lawmakers wanted to exclude Mr. Lungu, they would have made that intention clear. For example, they quoted the Second Amendment of the Constitution of the United States of America. This introduced term limits. The provision included text that restricts application of the limit to the president at the time. So it reads, "No person shall be elected to the office of president more than twice, but this shall not apply to any person who may be holding office of president at the time this article was proposed by Congress." Clearly, the framers intended the law to apply after the sitting president's term had come to an end, and they stated thus. The court also drew attention to Article 35 of the 1991 Constitution when Zambia retained to multipartyism. The article contained the following text. "After the commencement of this constitution, no person who has held office as president for 2 terms shall be eligible for re-election to that office." We note here that there was deliberate text included to specify that such limitation would only apply after the Constitution was enacted. Without that provision, then President Kenneth Kaunda, who had served multiple 5-year terms prior to that point, would have been excluded. So it is the intention to include him that had to be noted, absent which his exclusion was going to be automatic. And for perspective, let us step back to the constitutional regime as at 2015. Article 139, Section 12, Clause C said, where an act passed after the commencement of this constitution, for example, the 2016 Constitutional Amendment Act, repeals any provision thereof, then, unless the contrary intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect. This clearly implies that where a new law changes something that was disallowed or allowed previously, unless something is stated explicitly, the new change shall not apply to anything that happened prior to its enactment. Now, applying this same logic to Mr. Lungu's case, the argument is that the changes to the definition of what qualifies as a term, which were passed with the 2016 Amendment Act, may not be applied retroactively to definitions at the time or before the new law took effect, unless such intention was expressly stated within the law. Therefore, instead of requiring explicit terms to exclude Mr. Lungu as his lawyers claimed, the opposite appears to be true. If it were their intention, the lawmakers would have stated explicitly in transitional provisions that Mr. Lungu's first term not be counted as a term because it fell short of a standard the new amendment has created. And this view is supported by another submission from the Lungu lawyers, who submitted that a report from the technical committee charged with drafting the constitution at page 284 and 285 shows that the committee were alive to the circumstances of the incumbent president, Mr. Lungu. Therefore, it doesn't seem like the legislature erringly omitted to provide transitional provisions that accommodated Mr. Lungu's unique situation. So, the applicable transitional provisions should remain the ones found under Article 139 of the Constitution in force at the time. And as if to complicate things even further, when it came to the question specifically on Mr. Lungu's eligibility in 2021, the court says, as regards the second question, whether Mr. Lungu is eligible or not, it has become odious, and we shall not consider it. What does that mean? If we read the laws together from both constitutional periods which his tenure straddled, is he still eligible? The substantive question on whether Mr. Lungu is eligible to recontest in 2021 does not appear to have been answered conclusively. What are your thoughts? And if there's any other topic you would like us to address in future, let us know in the comments below. Like, comment, subscribe, and keep sharing.